The independent contractor in the state of California, what you need to know. My name is Gabriel Sandoval, and this is The Legal Issue. Thank you for tuning in, and welcome to The Legal Issue, channel where we discuss various legal issues people often ask about, issues that are trending throughout the state of California, as well as federal law. I'm Gabriel Sandoval, attorney in Los Angeles, California. The legal issue for the day concerns independent contractors and the legal issues that need to be considered. This is a hot topic throughout California as well as different states throughout the country, especially with the advent and popularity of tech-based companies such as Uber and Lyft. But this area of law isn't limited to large corporations. It's an issue that affects all companies, both large and small. It is also an issue that affects workers. There are plenty of legal issues to address. Primarily, I'll be discussing how a court approaches this issue, what the consequences are for misclassification, and what employers, as well as employees, need to look out for. Again, this segment pertains to California law only, and like any law, it is subject to change. The distinction between independent contractor versus employee is an issue that has been a constant battle across courtrooms throughout the state of California. It's an issue that determines what kinds of duties, rights, and remedies the parties have when there's a disagreement about money or when an injury has occurred on the job site. Thus, understanding the distinction is very important at all stages of a relationship. For instance, when there is a dispute about money, an independent contractor will have to battle or file a case for breach of contract in civil court, where the damages will generally be limited to the value of the contract as well as any foreseeable damages. Whereas a worker or an employee may have a case for unpaid wages under the California Labor Code, wherein the damages may vary from unpaid wages, including overtime, violation in meal and rest breaks, as well as waiting penalties under the code. If there has been an injury on the job site, an independent contractor will have to file his or her case in civil court, where damages are practically an open field from medical expenses, lost earnings, pain and suffering, and more. However, the injured party in a civil suit has to prove liability or fault. The injured party will need to demonstrate that his or her injuries were the fault of the company, that the company breached some kind of a duty of due care, which can be difficult in it by itself. Whereas an employee will need to file his or her injury case before the Workers' Compensation Appeals Board and seek compensation that is often limited to disability benefits that are determined through medical evaluations. The workers' compensation system is a no-fault system, meaning the court does not examine concepts such as negligence, although the employer does have limited affirmative defenses. One added caveat is that the worker does not have the right to a jury trial in the workers' compensation system. The question is, how should a business owner approach the issue? Can a company simply handle this matter with a contract? The most common example or the most common issue I see is one where a business owner assumes that everything has been taken care of. There are no issues because the worker or the independent contractor filed or completed a 1099 instead of a W-2. In addition, the parties may have even signed a contract clearly stating in bold and capital letters, underlined, this is an independent contractor agreement and no employment has been formed. I have literally seen contracts like that. The problem is that these practices are not binding in a court in California, and these practices can go completely ignored altogether. Rather, the court will take it upon itself to analyze the working relationship between the parties carefully, and depending on whether the case is for unpaid wages or for an injury case, the courts employ a different analysis. There are two Supreme Court cases that listed the factors that need to be considered when the issue is brought before a judge. ABC test, for instance, adopted in 2018 in the case of Dynamics Operations West versus the Superior Court, lists the factors that need to be considered in a case for unpaid wages, whereas the Borrello factors adopted in 1989 in the case of S.G. Borrello and Sons versus the Department of Industrial Relations outlines factors to be considered in a workers' compensation setting. As you can see, there are a multitude of factors that will be considered when a judge is making this determination. And depending on the case, once again, one test will be employed over the other. The key thing to remember as we look at these factors is there is no single factor that is controlling. The court will balance all of the circumstances regarding the working relationship before drawing a conclusion. Dedicating an entire segment on the ABC test as well as the Borrello factors in order to help you understand how they work on a case-to-case basis. Despite the seeming variation between the two tests, both have their similarities, and the courts tend to rely heavily on a few factors. Generally, it boils down to this. What does the relationship look like? Does it look like an employment relationship where one party has control over the other? Or does it look like a contract where somebody gets paid for a project or service that is completed over a set period of time? Is the worker engaged in work that is part of the business's regular course of business? In the case of rideshare companies, it appears that the courts are essentially telling them that their drivers are engaged in conduct that is part of the company's usual course of business. After all, Uber and Lyft are 99% about drivers taking customers to their destinations, and thus they won't allow them to avoid compliance with the labor laws simply because they found an innovative way at sourcing out their work. Lesson of the day is this. If you are a worker, don't be too quick to conclude that you don't have certain legal rights because you're supposedly an independent contractor. Typically, you'll be burdened with diligently pursuing your rights. A prolonged delay can affect your ability to file a claim later on. And if you are an employer, be careful in thinking that you can easily classify someone as an independent contractor by how the person is paid or contracts that are signed. The legal consequences of making incorrect assumptions can have severe financial consequences. If there is an injury on the job site, your company, even you personally, can face financial liability for medical expenses. And if there's a dispute about wages, you could face wage penalties, overtime claims, etc. under the labor code. These issues are addressed in a different segment as well. As always, this is meant as a general discussion only, not meant to be construed as legal advice. Laws are always subject to change, and every case is different, so please consult with an attorney if you have a specific legal issue. If you would like to consult with my office, we can always be reached at 1-800-919-8959. Please remember to like our video, subscribe if you'd like to keep seeing new content. If there is a legal issue you'd like us to discuss, feel free to shoot us an email at info@thelegalisssue.com. Any personal information will remain confidential. Once again, I'm Gabriel Sandoval, attorney in Los Angeles, California. On behalf of The Legal Issue, thank you for your time. Until the next one.